The statement of Ambedkar, which said that whatever may be the constitution, whatever may be the rule, whatever may be the interpretation of the court, eventually the persons who govern these institutions, their character is what would matter. That statement is of extreme importance to us because we have, on the one hand, institutions created by the constitution, and on the other we have individuals who are citizens. The question is there a disjunct between them? Is there any other institution which governs or shapes the character of the individual? We have given us the constitution with all attributes of a good democracy. But then the requirement of providing people with character has remained unanswered, and these very people continue to govern the constitution. So the question which needs to be answered today is that how do we fill the gap, if at all there is a gap between the institution and the individual? If the constitution is a framework for working of institutions in a democratic way, in a consistent way, then which is the institution, which is the organization which would supply citizens to govern these institutions? There seems to be a gap. Where does that come in? That requirement of having qualitative persons governing the institution. What have we taught our citizens? We have said that you claim rights under Part 3. You are given freedoms to enhance your creativity, to express yourself, reside anywhere that you want, form any organization that you want, and that these are the cherished rights, and any interference by the state with these rights will be struck down by the court. We have also the great value of equality, and that any kind of a discrimination, either by the state or any other state-like institution, will again be interfered by the court. When we claim rights, a right of freedom, then we are asserting our individual self. Equally, when we claim the right of equality, we are again claiming the right of individual self. Both these are extremely important, which will enable an individual to develop. There is another aspect of it, that is, what is it that would govern we as against I? Is there anything called the living in a society for the sake of the society and for the goodness of the society, with respect to which one would immediately resort to the powers of the state to regulate the liberty or the right to equality? This is very distinct from the living of an individual in a society. This is a very difficult distinction that one needs to draw. the living of an individual in a society must be distinguished from the obligation of a state to ensure that the rights are exercised in a manner that would not harm others, or the restrictions, the specified restrictions provided under 19(2), 3, 4, or as provided in 17 and so on. The power of a state to regulate exercise of a right must be distinguished from the role the individual will have in a society. This is an extremely difficult concept to understand, because the role of an individual in a society arising from within the individual, not from the state, that is fraternity. We should again and again draw out the distinction between fraternity, which is arising out of the idea of an individual with respect to his relationship with his fellow being, then that of the power of a state to enforce individual action as legitimized by the Constitution. While freedoms and equality are assertion of an individual self, fraternity, in its most sacred and a very delicate sense, is a feature of selflessness. While an individual claims his rights, I want the freedom of speech, or I want the freedom to settle anywhere in the part of the country, or my right to life as developed by the Supreme Court, or the right to claim. When it comes to a fraternity right, it is not assertion of the individual, but a selflessness within himself with respect to his brothers and sisters around him, his society. This is involution as against evolution. An individual would say that in this context, it may not be necessary for me to exercise my right to speech. I will permit, in this case, my sister to talk, or my brother to exercise that right. That act of his is not an act of assertion of a right, but that is an act of withdrawal of one's rights into oneself and permitting the society to go ahead. That is the biggest distinction between the rights of freedom and equality as against the feature of fraternity. Just imagine, can there be a society subsisting without fraternity? No? There will be a constant strife, because each one is claiming a right, each one is claiming an equality, principle of equality. And that will be enforced by the state if it is exceeding. But now conceive of a situation where instead of asserting a right, an individual is looking at a society in which he thinks of his brothers and sisters to be equally exercising the right at the cost of his own. This is a principle which has not been developed in the West, and we have also not applied such a principle in this subcontinent or by the Supreme Court. How do we test this? How do we therefore can this principle of fraternity be couched in the concept of a right, or could it be couched in the concept of a duty? Can you say that it is my right of fraternity that somebody should not, the community or group or an individual should not have done that because it harms the society at large? It can't be claimed as a right. That is why they say fraternity is not a right which could be claimed at all. Can somebody seek enforcement of it as a duty? Even that's not possible. That is the reason why you have rights and duties alone to be conceived as enforceable in the Constitution. But therefore, where does it exist in the Constitution? What is the role of courts with respect to the concept of fraternity? There are a large number of judgments of the Supreme Court on fraternity. Even in Indira Sani's case, there is a reference to it, saying that reservations are a matter of right, but they could also be supported in the context of fraternity. But how is it that, how can a court of law recognize what is the minimum content of a fraternity and at least recognize it and give a declaration of that nature? Take, for example, the present situation of COVID-19. As it started, instead of people exercising their right to their professions or to their avocations and seeking to claim such rights, have withdrawn because of the situation, as it were, and instead of claiming any right, have contributed enormously. A large number of organizations which have come forward. There are a large number of individuals who have contributed, large number of lawyers who have contributed. This is an individual act of selflessness. Why have they done that? The reason for doing that is the belief that my well-being would not be different from that of my society, and that my happiness can be found only in the well-being of the society. What would we call that? Will we call that a right, or will we call that a duty? It has no place in the enforcement mechanism. That is the reason why it has remained from being a part of adjudication, because people don't go to a court of law for the enforcement of that. It is an action arising out of empathy. It is an action which arises out of the recognition that my well-being will depend upon the welfare of the society. It's a very difficult point that I am trying to put forth, particularly in the context of a COVID, because we see now the play of fraternity multifold. People have remained at home, given up their professions, given up their right to move around. It's all because of the reason that one's life is in danger, at the same time the life of others also could be put in danger. So therefore the restraint from the exercise of the right that has already been given to individuals. The courts have given an interpretation to fraternity only in the context of the fundamental rights. Courts have never looked at fraternity as an independent feature which will not be exercised as a right or a duty, but will be exercised as an act of relinquishment. This concept is difficult to understand, and it's my belief that such a concept cannot arise in the Western philosophy also. It could arise in our subcontinent with a particular background that we have in this country. And recognition of this principle can be done in this manner. Now, once we see the disjunct between the character of an individual on the one hand and the constitutional framework for for the governance of institutions, then how are we to fill in this gap of building the character of an individual with respect to which there is no institution? A virtue jurisprudence becomes necessary there. There must be a recognition of the fact of the values of an individual, because the values of the individual itself will shape the citizen to become an ideal person to occupy the positions provided under the Constitution. Now, which is this area in which you manufacture individuals who would be such that primarily they will exercise the principle of fraternity and at the same time exercise their freedoms and their claim for equality. When we are talking about an individual, first of all, giving emphasis to the feeling of fraternity, then the building of such character, the manufacture of such people becomes important, and we must look at avenues and institutions where such a thing would happen. In the normal course, one would refer to it as a place where the character is built in the family itself, in the education that he receives, in the values that he is told. Can there be a mechanism, can there be a situation where a court would recognize that the character of an individual to think primarily of his fellow beings needs to be promoted, and for that reason we need to have such and such institutions, such and such mechanisms. Somehow we could not work that system. Virtue jurisprudence is seamless. I am talking of the concept of dharma. What it does is that it does not bifurcate state on the one hand and individual on the other. There is this virtue jurisprudence which overarches, encompasses the individual and the society. Every walk of life is governed by a principle of individual character, a principle of state character, a principle on the basis of which an organization could run. Each one of them has a particular feature, and this feature has an underlying principle of virtue, and it governs everything seamlessly. In Kautilya's Arthashastra, there is a reference to that. And some modern writers in the West have also referred to it. We need to work on that. What we need to see is that is it possible that without in any way undermining the constitutional protection of the individual's rights and freedoms, and without reference to the state's power. How does an individual build his character keeping in mind the welfare of the society? There must be an institutional mechanism for that. It is not a wishful thinking. It is not a religious prescription. It is, in my view, a necessity to create an institution that would build an individual character, and such character would encompass not only his dealings but also each of the institutions that govern the country. I would want to read that passage of Ambedkar. It was almost quite close to what I'm saying. This is in the context of the assembly debates, where he raises the question of what does a social democracy mean. He says it means a way of life which recognizes liberty, equality, and fraternity as the principles of life. These principles of liberty, equality, and fraternity are not to be treated as separate items in a trinity. They form a union of trinity in the sense that to divorce one from the other is to defeat the very purpose of democracy. I'll skip some portions of it. Equality, he says that liberty cannot be divorced with equality, equality cannot be divorced with liberty, nor can liberty and equality be divorced from fraternity. Without equality, liberty would produce the supremacy of few over the many. Equality without liberty would kill the individual initiative. Without fraternity, liberty would produce the supremacy of few over the many. Without fraternity, liberty and equality would not become a natural course of things. It would require a constable to enforce it. We must begin to acknowledge the fact that there is a complete absence of two things in the Indian society. There is equality as well as liberty to start with. He therefore prescribes that it goes without saying that an attitude of indifference with reluctance to honor and protect the rights of others who are related to some bond of fraternity, particularly those who are dependent on the states, is various organs and the rest of the society for the protection of the lives and liberties and for justice would be incompatible with the noble ideals for which the Constitution of India has been enacted. So he is emphasizing the role that fraternity will have in the Constitution. We could not take this forward much in the interpretation of the Constitution. There is one phenomenally insightful writings of Aurobindo on fraternity yet again. He says very beautifully a new aspect of it he has referred to, because he says fraternity is something which arose out of the French Revolution, and that concept is very, very different from that of the perspective that he has. Three ideals of ultimate aims of modern civilization, which were proclaimed at the time of the French Revolution, are generally known in our language as the three principles of liberty, equality, and amity. He says amity. But what goes in the name of fraternity in the language of the West is not amity. Amity describes the state of mind. That's what he's saying. Because he says fraternity is something which is relating to institution of the state, the nationhood. Aurobindo is not talking of the nationhood. It is talking about a state of mind. That is what I was emphasizing in the beginning of my speech. It is the idea that an individual has about his society, his brothers, his sisters, his community, his people. There is something which in him which says that their happiness is equal, or sometimes he wouldn't mind to give up his happiness for the purpose of his community's happiness. And mind you, this is not religion, this is not philosophy, this is constitutional governance that I am talking about today. That's the distinction that we are drawing in today's speech. We are talking of constitutional governance of with the feature of fraternity, and this concept of fraternity is the individual character, and it is a matter of concern for the constitution. Till date it has spoken about institutions, till date it has spoken about the rights and duties. There must be a place where the character is carved, is developed, and we must think of an institutional mechanism for that. I have tried to develop this, and I have been working on this for some time, on which I may eventually write a book on this. But this is the most important feature of the Constitution that we must consider and develop it. And it is my belief that we will be able to do it considering the great knowledge systems that we have. The idea of Aurobindo has come very close to it, but it is not couched in the constitutional terminology. And youngsters like you, I would want you to work on this and develop this concept and take this society to the realms where the individual will first think of his society rather than the claim for his rights, because his rights are anyway there. Those rights are far more. We must be very careful in dealing with this constitutional aspect of it, because fraternity should not be taken anywhere near the state's power. It is exclusively and totally relatable to the individual character and nothing to do with the power of a state. And situations like this will give us an idea as to how this concept of fraternity, as I have just spoken about, is embedded in our character. The effort must be to bring that out, give a recognition to it, give a declaration to it, and say this is what we are. And such recognition will give strength to the individual, and he will get to know that fraternity is the way of life. Incidentally, we have the rights and freedoms. This is the short speech or discussion that I wanted to have with you at a time when we are all facing with the pandemic, and we are looking at ourselves, we are looking at our family, we are looking at our friends. I just now had a webinar on for the Punjab and Haryana High Court, where a large number of lawyers were concerned about the time when the courts are going to reopen. So we have to today balance between the safety and security of all of us, because this pandemic has really endangered the lives. It's not simply a matter of fever or cough or some irritation. It is a question of life and death. So keeping this in mind, we will have to think about how to commence our practice, our profession. So we need to balance that, and for that we will have to take steps. We'll have to ensure, first of all, our safety and the safety of our brethren, and we must adopt such technology as is available, and cooperate to ensure that people who are in need of justice, people who are in jail, people who need anticipatory bail, get the relief. You can't say that wait for 3 months to them. We are under great pressure, and whatever it takes in the best manner, by adopting all measures of safety to ensure that justice delivered to individuals must be done. Must be done. Even if somebody is asked a question, even if the lockdown is lifted, people will have to follow social distancing for a long time, it seems. Yes, you are right. You are right that social distancing is absolutely necessary. But then, till the social distancing is maintained, the question is, are we going to not give any justice to people who need it? It's not possible. We will have to balance it. We will have to adopt ways and means to ensure that people get justice. Courts are doing their best. They are listing matters. I believe from next week, number of matters to be listed in the Supreme Court is going to increase multifold. And after notice matters are also going to come. And I think we must adopt technology, and we must adopt also methods by which we reduce our arguments. We must be precise in our submission. If at all we have to, pleadings are anyway there. Over and above pleadings, our written submissions are virtually pleadings, but instead of that we will have to change ourselves. We will have to prepare submissions of 1 page or 2 page, which are virtually like how we talk in the court, and make it easy for the judges to quickly give a decision. This may not be a situation where the courts are going to deliver precedents in the nature of judgments for time to come. These are the times for decision making only. So therefore we are expecting that quick decisions are taken by the judges, and advocates will help the court in doing that. I think technology is something which we have got used to, and over the last 1.5 months, people have been using the web-based technologies to communicate with each other and transfer information and knowledge substantially. I think that's the way ahead. Ganesh has a question, or he's saying, recently there was a huge debate on why Ramayana Mahabharata telecasting on TV. Do you think that's a, there is no 1 minute, I can't see the full question on that. That debate is irrelevant for interpretation of the Constitution. The message in Mahabharata and Ramayana are basically in the nature of stories, but then the philosophical part of it and its application to the constitutional governance requires a deeper understanding of this, and we must study them in detail and then apply it and discuss it and apply it to the extent possible. Is it observed that while managing this epidemic, a number of rights of individuals like the right to property, right to privacy, something it's not opening up. I think I am not able to read the entire message, but right to privacy and so on are being violated, in the sense that yes, there is no access to justice. That's the difficulty. There is no access to justice because the courts are closed, and efforts are being made. Apart from completely relying on courts in matters of adjudication, we could also think of mediation matters, which is of course not possible in criminal matters. Court must think of it. Whoever is manning the institutions surrounding the institutions concerning mediation, like the NALSA, must come up with protocol for how to deal with mediation in a situation like this. it's very, very important for lawyers to learn the techniques of mediation. And if there is, say, for example, a case where both the lawyers are willing, with the consent of the client, to mediate, they could easily communicate with each other on telephone or web and arrive at a decision for resolving the problem. And I think we should do that. And I take leave. Thank you very much for giving me this opportunity. Thank you, Ganesh, once again. I wish you all the best. Take care, stay at home, ensure that yourself and your family is taken care of, and keep smiling. And thank you for giving me the opportunity. Thank you.